Hi, everyone. Thank you so much for coming to class tonight. Tonight, we are going to be covering part 2 of the residential purchase contract. We're going to go ahead and just pick up on the top of page 3, so follow along with me. As a reminder, because this class is being recorded, we do want to keep the questions to the specific topics that we're discussing tonight. If there's any questions that you might have after, please let me know. We can discuss it. And as a reminder, I know it's long and boring, but we literally read this line by line. And then after we've read a section, we'll kind of talk about it, maybe go over some examples, things like that. So let's go ahead and dive into it. Loan application. Unless previously completed within 3 days after contract acceptance, the buyer shall provide a lender with buyer's name, income, social security number, premises address, estimate of value of the premises, the mortgage loan amount sought, and grant lender permission to access the buyer's tri-merged residential credit report. Because of the situation that we got into back in like 2008, 2009 with the whole market crashing and everything, maybe it was 2010, the lenders have been doing a better job of getting this information up front so that when they issue a pre-qualification, you know for sure that they have done their due diligence and that people are going to qualify for the home. It is very rare when you get a pre-qual from a lender that you get under contract and then they come back and say, oh, sorry, I can't approve your client. If that does happen, it's usually right before close because maybe they went out and bought a house, maybe interest rates went up, stuff like that. Loan processing during escrow. Within 10 days after receipt of the loan estimate, the buyer shall provide lender a notice of intent to proceed with the loan transaction in a manner satisfactory to the lender and provide a lender all requested signed disclosures and the documentation listed in the LSU at lines 32 to 35. Buyer agrees to diligently work to obtain the loan, and will promptly provide the lender with all additional documentation requested. The following class that we're going to have, our upcoming class, is going to be over the actual pre-qualification. We're going to have a lender come in. They're going to talk to us about the financing types, and I'm going to have them go through the pre-qual in detail because we as agents should know what it is, especially because if we are representing a seller and a buyer is giving an offer on our seller's home, we're going to be asking for the pre-qual, proof of proof of funds if it's cash. So we have to know what we're looking for and we have to be able to understand what each item means. Like if you get a pre-qual and it's saying they don't need a gift, but then later in the transaction, you get an LSU and that LSU now stating a gift, well, that wasn't disclosed up front. Not that it necessarily is going to hurt the transaction, but it could if then that gift person backs out and now they don't have enough funds to close. So it does have to be disclosed. So just understanding what to look for and line 32 through 35 is really important of it. Type of financing, you've got conventional, FHA, VA, USDA, assumption, seller carryback. You've got a blank box. This could be hard money loan. It could be cash. If I have a cash deal, I always check this and I put cash. Do you have to? Absolutely not, because if you're doing a cash deal, section 2, which is the section we're covering right now, does not apply. There is no financing, but I always like to put it. Just me. Other agents might balk at it like, oh, you don't need to put that. That's fine. You know, you do you. I'm going to do me. Loan, but no, you don't have to. I just do. Because I feel like if I'm going to get an offer, this is one area that I'm always going to go back and double check. Okay, is there financing on it? Even though on the front page it said cash due at close. Loan costs, all costs of obtaining the loan shall be paid by the buyer unless otherwise provided for herein. Those fees could be covered by like a seller concession. Seller concession, if any. In addition to other costs, seller has agreed to pay herein, seller will credit buyer a certain percent of the purchase price or a set dollar amount. The seller concession may be used for any buyer fee, cost, charge, or expenditure to the extent allowed by the buyer's lender. And also, depending on what type of financing, it will determine how much seller concession a lender will allow. For example, FHA, the max is 6%. Conventional, depending on how much their down payment is, it's either 3, 6, or 9, I believe. And there is a cheat sheet floating around there. I believe I have a copy of one. I can get it to you if you send me an email, but you'll have to remind me to get it to you later. This seller concession has absolutely nothing to do with the seller compensation. I need you to understand that. The seller compensation is completely separate than a seller concession. Now, a seller concession can be used towards the buyer broker agreement if the seller is not willing to pay your commission, but it is completely separate. But they can use the concession to pay it if the seller is not willing to and the buyer has to pay for it. It's very, very important for you to understand that. It is tricky, and it has fooled even the best of us, especially with these new changes. Speaking of, the buyer shall immediately notify seller of any changes in the loan program, financing terms, or lender described in the pre-qualification form attached hereto, or LSU provided within 10 days after contract acceptance, and shall only make any such changes without prior written consent of the seller if such changes do not adversely affect the buyer's ability to obtain loan approval without PDD, that is a hard letters group to say, conditions, increase the seller's closing costs, or delay close of escrow. The best example that I can give you is the type of financing. If you go under contract and the financing is FHA, no, back up. If you go into a contract and the financing is conventional and you want to switch to FHA, you can't just do that because that does not help the seller. If it's a condo situation, the condo may not be FHA approved. So before you make any changes, you have to have that conversation with the seller's agent and of course with the lender, if it is a townhome or a condo, to make sure that they can do FHA. Another good example of a change would be if it's a cash offer and they decide that they want to go ahead and do financing. Well, that completely changes not only the financing type, but also the appraisal, because you have to have an appraisal on a finance deal. So again, if it affects the seller in any way, you just have to get it in writing. Appraisal contingency, the buyer's obligation to complete the sale is contingent upon an appraisal of the premises acceptable to the lender for at least the purchase price. If the premises fail to appraise for the purchase price in any appraisal required by lender, buyer has 5 days after notice of the appraised value to cancel this contract and receive a return of the earnest money, or the appraisal contingency shall be waived unless otherwise prohibited by federal law. So if you get a low appraisal, you do have the option to ask the appraiser to reconsider their value. And that is getting comps together. It is getting a list of upgrades together. And quite frankly, you should have had this as a package before the appraisal actually went out there. But if you didn't and it came down low and you feel that there's additional comps that they could consider, you can definitely ask them to do that. They do not have to do a reconsideration. And again, depending on what type of financing there is, that appraisal may stick with the home for 6 months. Like FHA sticks with the home. VA financing sticks with the buyer. Sellers could order an additional appraisal. Like if it's conventional and it comes in low and they're not happy with it, the seller could easily order it, or the buyer could. Doesn't really matter who pays for it, but another one could be ordered, because what is an appraisal? It's an opinion of one person using a formula or mathematical, whatever they use, algorithm.
Right.
And that is a conversation, if you're representing a seller, that you should have up front. If your home doesn't appraise for the value, this could be something that we could do, or you might have to consider dropping the price, meeting in the middle, like whatever it might be. But they need to understand that if they can't come to an agreement, the buyer can cancel and they get their deposit back. The appraisal cost is negotiable, believe it or not. Usually the buyer pays for it, but you could ask the seller to pay for it. You could also ask for it to be split. If you ask the seller to pay for it and they agree, at the time of payment, it is required by the lender and is non-refundable. If seller is paying the initial appraisal fee, the fee will or will not be applied against the seller's concessions at close of escrow. So that's basically meaning the buyer is reimbursing the seller for paying for it. Maybe the buyer doesn't have the extra funds, something like that. If buyer's lender requires an updated appraisal prior to close of escrow, it will be performed at the buyer's expense. Any appraiser lender required inspection costs shall be paid for by the buyer. It kind of contradicts what I just said, but if the seller wanted to order their own independent appraisal, they could. Nobody's going to stop them. Any questions? Okay, that concludes part 2. So the previous class, if you weren't here for that talked about page 1 and the cover sheet, page 1 and page 2 of the contract. And then we continued on page 3 this evening and concluded part 2, which dealt with financing. So let's go into part 3 of the purchase contract, which talks about title and escrow. And there's a lot of information in here that is not my expertise. This is for the lender, but we still have to read it. So it's boring. Sorry. The contract shall be used as escrow instructions. The escrow company employed by the parties to carry out the terms of the contract shall be. Snap Title is our affiliated company. So if you want to take a quick screenshot of this, you can put this into your template. And so it auto-populates every time you open a new file. So if you want to do that, I'll give everybody a quick moment to take a picture. Perfect. So Snap Title, Patrick Bailey. I have Amy Dalton on here as well. She's been helping out while Patrick was out sick. The address is 4145 East Baseline Road, Gilbert, Arizona, 85234. Email Patrick at snaptitle.com, 480-870-8013. So why do we want to use our title company? Because we want control over it. We want to make sure that we are working with the people that are going to have our client's best interest. All title companies do. They're a neutral third party. But maybe we get a discount because it's an affiliation. Maybe they pay for my marketing, so I want to give them work. That's the main reason why we do the kickback, is because they do invest a lot in us. So if you can put it in all of your contracts, definitely fight to get it. Depending on what kind of market we're in, buyers or sellers, it's a little harder to get the escrow company that you want. But as long as you're trying, then they appreciate it. They know they're not going to get all of them. Title investing. The buyer will take title as determined before close of escrow. If buyer is married and intends to take title as his or her sole and separate property, a disclaimer deed may be required. Taking title may have significant legal, estate planning, and tax consequences. The buyer should obtain independent legal and tax advice. Because what are 2 things we can never get? Legal and tax advice. Title commitment and title insurance. Oh, this is so fun to read, so bear with me. Escrow company is hereby instructed to obtain and deliver to buyer and seller directly, addressed pursuant to 8S and 9C or otherwise provided, a commitment for title insurance together with complete and legible copies of all documents that will remain as exceptions to buyer's policy of title insurance, quote unquote, title commitment, including but not limited to conditions, covenants, and restrictions, otherwise known as CC&Rs, deed restrictions, and easements. The buyer shall have 5 days after receipt of the title commitment and after receipt of notice of any subsequent exceptions to provide notice to seller of any items disapproved. Seller shall convey title by warranty deed, subject to existing taxes, assessments, covenants, conditions, restrictions, right-of-ways, easements, and all other matters of record. Buyer shall be provided at seller's expense. Keyword, seller's expense. An American Land Title Association, otherwise known as ALTA, homeowners title insurance policy, or if not available, a standard owner's title insurance policy showing title vested by buyer, vested in buyer. Buyer may acquire extended coverage at buyer's own additional expense. If applicable, the buyer shall pay the cost of obtaining the ALTA lender title insurance policy. So this section is something that I always make sure I talk about when I'm representing a seller. Because the seller, when they get their settlement statement, they're going to see this $3,000 charge depending on the home, the purchase price of the home, because the amount of the ALTA depends on the purchase price. They're going to see this expense and they're going to go, what is this? And why didn't you ever tell me about it? It's in the contract, but do they ever read it? Absolutely not. So we need to do our job by educating our clients. Now, the last sentence said, if applicable, the buyer shall pay the cost of obtaining it. That's typically seen more often in new builds or private builders because they don't want to pay for it. They're going to put that cost on the buyer. It is negotiable. Everything's negotiable. So if the buyer wants to pay for the seller's closing costs, they are more than welcome to, and this is part of their closing cost. But again, everything has to be agreed upon and part of the contract. Page 4, additional instructions. Escrow company shall promptly furnish notice of pending sale that contains the name and address of the buyer to any homeowners association in which the premises are located. If escrow company is also acting as a title agency, but is not the title insurer issuing the title insurance policy, escrow company shall deliver to buyer and seller, upon deposit of funds, a closing protection letter from the title insurer indemnifying buyer and seller for any losses due to fraudulent acts or breach of escrow instructions by the escrow company. All documents necessary to close this transaction shall be executed promptly by seller and buyer in the standard form used by escrow company. Escrow company shall modify such documents to the extent necessary to be consistent with this contract. Escrow company fees, unless otherwise stated herein, shall be allocated equally between seller and buyer. In the state of Arizona, buyer pays their own, seller pays their own. Escrow company shall send all parties and brokers copies of all notices and communications directed to seller, buyer, and brokers. Escrow company shall provide brokers access to escrowed materials and information regarding the escrow. If an affidavit of disclosure is provided, escrow company shall record the affidavit at close of escrow. Again, not my area of expertise. If you have questions about this, call your title rep. Tax prorations. Real property taxes payable by seller shall be prorated at close of escrow based upon the latest tax information available. Release of the earnest money. In the event of a dispute between buyer and seller regarding any earnest money deposited within an escrow company, the buyer and seller authorize the escrow company to release the earnest money pursuant to the terms and conditions of this contract in its sole and absolute discretion. Buyer and seller agreed to hold harmless and indemnify escrow company against any claim, action, or lawsuit of any kind and from any loss, judgment, or expense, including costs and attorney fees, arising from or relating in any way to the release of the earnest money. So when something happens in the transaction and your buyer is asking you, well, what happens to my earnest deposit? The best way, in my opinion, to answer this is that the contract is very buyer friendly. However, the escrow company has the final say in where your money goes, and they go by what is written in the contract. If the seller and buyer don't agree with like who it's being released to, then mediation can start, but there is a cost to that and it's going to be paid by them. But always fight for your client. And understanding what the contract says, understanding the timelines, understanding what or how to read a prequal, because I have one earnest deposit for my clients because I understood the prequal and I caught that they were giving a gift and now there isn't a gift and they didn't disclose it and da 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 da. So again, it's just understanding, and every contract's going to be different, but these are the basics. So you got to understand the timelines. You got to understand what is in your client's best interest. And at the end of the day, escrow company has the final say. And they go by what's written in the contract. So always tell your client that. Prorations and assessment and fees. All assessments and fees that are not a lien as of close of escrow, including homeowners association fees, rent, irrigation fees, and if assumed insurance premiums, interest on assessments, interest on encumbrances, and service contracts shall be prorated as of close of escrow or otherwise specified. Assessment liens. The amount of any assessment lien or bond, including those charged by a special taxing district, such as a community facilities district, shall be prorated as of close of escrow. Sorry. Any questions so far? Okay. So that section we just covered was the title and escrow. Again, talk to your title rep if you have questions about the process. They are always happy to discuss it, and we will have a class on title and escrow so that we can get a better feel of what they do on their end for our clients. Because again, we should know the process in and out. Okay, number 4, section 4, I should say, disclosure. This is one of your 3. I don't know if I'm wording that right. Hold on. No, I'm not. Okay. Disregard that comment. Okay, disclosure. Seller property disclosure statement, otherwise known as SPUDS. Do not spell it SPUDS. It is not a potato. It is SPDS. And if you're gonna use that lingo when you're talking with your clients, you need to explain to them what that means. Just like the BINSR. Nobody knows what the BINSR is unless they're in real estate. The seller shall deliver a completed AAR residential SPUDS form to buyer within 3 days after contract acceptance. So that's one of your timelines that you need to know. So 3 days after contract acceptance. The buyer shall provide notice of any SPUDS items disapproved within the inspection period or 5 days after receipt of the SPUDS, whichever is later. So if you don't get this agreement until day 10 of your inspection, that's bad on their part. You now have 3 more days. I'm sorry, you now have 5 more days to just disapprove of it. And they were supposed to get this to you by day 3, but we're human. Sometimes we forget. And if you're representing the seller, we're pros. This document should be uploaded in the listing so that they can put it in their offer. Yeah. Insurance claims history. Seller shall deliver to buyer within, I'm sorry, let me start over. Seller shall deliver to buyer a written 5-year insurance claims history regarding the premises or a claims history for the length of time seller has owned the premises, if less than 5 years, from seller's insurance company or an insurance support organization or a consumer reporting agency, or if unavailable from these sources, from the seller, within 5 days after contract acceptance. Another timeline. So after contract acceptance, The seller's agent has 5 days to provide the buyer's agent with the insurance claims history, otherwise known as the clue. Buyer shall provide notice of any items disapproved within the inspection period or 5 days after receipt of the claims history, whichever is later. Good. This is an easy form to already have uploaded into the MLS because if you have it in the documents tab, when they put in their offer, that is your delivery. You do not have to resend it to them. If they ask for it, you can say it was in the MLS. They can clearly go to the history to see that it was uploaded in there and that you did provide it to them. So don't do your clients an injustice by not either uploading it or not knowing that you have to give it to them if it's not uploaded. Yeah. Foreign sellers, otherwise known as a FIRPTA. The Foreign Investment in Real Property Tax Act. If applicable, if seller is a non-resident alien individual, foreign corporation, foreign partnership, foreign trust, or foreign estate, otherwise a foreign person. Seller agrees to complete, sign, and deliver to escrow company a certificate indicating whether seller is a foreign person. FIRPTA requires that a foreign seller may have federal income taxes up to 15% of the purchase price withheld, unless an exception applies. Seller is responsible for obtaining independent legal and tax advice. And this is a conversation that you can have with title. As far as I'm aware, the exception is if it's their primary home and the purchase price is less than $300,000. Do not quote me on that. Things change all the time. Talk to your title rep or seek legal and tax advice. Lead-based paint disclosure. If the premises were built prior to 1978, the seller shall notify buyer of any known lead-based paint or lead-based paint hazards to the premises, provide buyer with any LBP risk assessments or inspections on the premises in seller's possession, provide buyer with the disclosure of information on lead-based paint and lead-based paint hazards, and any report, records, pamphlets, or other materials referenced herein, including the pamphlet Protect Your Family from Lead in Your Home, collectively the LBP information. Buyer shall return a signed copy of the disclosure of information on lead-based paint and lead-based paint hazards to seller prior to close of escrow. So line 173 and 175, you need to check one of these two boxes when you submit your offer if it applies. If it does not apply, leave a blank. So 173 is stating that the lead-based paint information was provided prior to contract acceptance, and the buyer acknowledges the opportunity to conduct a lead-based paint risk assessment or inspections during the inspection period. This form was either emailed to you prior to you putting your offer in or uploaded into the MLS. That is what you check here, if one of those two things happened. If it did not happen, then you check 175, the seller shall provide lead-based paint information within 5 days after contract acceptance. This is another timeline. So 5 days after contract acceptance. The buyer may, within 10 days after receipt of the lead-based paint information, conduct or obtain a risk assessment or inspection of the premises for the presence of lead-based paint or lead-based paint hazards assessment period. Buyer shall have 5 days after receipt of this document or 5 days after expiration of the assessment period to cancel the contract. So, a lot of the homes were built before 1978. If it is important to your client, this is something that they should do. But if they are going to do it, they need to know, and you need to know, that it can take 3 weeks just to schedule. So that is going to affect your inspection period time. So you may want to consider asking for a longer inspection period so that you can conduct this inspection, investigation, whatever you want to call it. Buyer is further advised to use certified contractors to perform renovations, repair, or painting projects that disturb lead-based paint in residential properties built before 1978 and to follow specific work practices to prevent lead contamination. If it was built before 1978, your buyer's initial line 181. If it was built after, they initial line 182. Affidavit of disclosure. If the premises are located in an unincorporated area of the county and 5 or fewer parcels of property other than subdivided property are being transferred, seller shall deliver a completed affidavit of disclosure in the form required by law to buyer within 5 days after contract acceptance. Buyer shall provide notice of any affidavit of disclosure items disapproved within the inspection period or 5 days after receipt of the affidavit of disclosure, whichever is later. Changes during escrow. Seller shall immediately notify buyer of any changes in the premises or disclosures made herein, in the SPUDs or otherwise. Such notice shall be considered an update to the SPUDs. Unless seller is already obligated by the contract for any amendments hereto to correct or repair the change items disclosed, the buyer shall be allowed 5 days after delivery of such notice to provide notice of disapproval to seller. So if you, for some reason, need to update the seller disclosure for any reason, maybe you're under contract and your roof leaks, well, that's something that wasn't in the original seller disclosures. You now need to update it and you now need to re-deliver it to the buyer, and they have 5 days to review it and they can cancel. Also, if you have a home inspection done and the contract falls out and you go into contract with someone else, that seller needs to update that seller disclosure with any items that needs to be disclosed. If it's a material fact, you have to tell the new person, and that's by updating the seller disclosures before you go under contract again. Any questions? Okay, so that was section 4. I think we've got time for, we'll probably just do one more section because the next section is pretty big and it's the due diligence, and I don't want to rush that one. That's a really important part of the contract. So let's talk about warranties. Condition of the premises. Buyer and seller agree that the premises are being sold in its present physical condition as of the date of contract acceptance. What does that mean? That means it's as is. Every home is sold as is. Doesn't mean they can't ask for repairs, but it's sold as is. Seller makes no warranty to buyer, either express or implied, as to the condition, zoning, or fitness of any particular use or premises of the purpose of the premises. However, seller shall maintain and repair the premises so at the earlier possession or close of escrow, the premises, including all personal property included in the sale, will be substantially in the same condition as on the date of contract acceptance, and all personal property not included in the sale or debris will be removed from the premises. Buyer is advised to conduct independent inspections and investigations regarding the premises within the inspection period as specified in section 6A. Buyer and seller acknowledge and understand they may, but are not obligated to, engage in negotiations or address repairs, improvements to the premises. Any and all agreed upon repairs, improvements will be addressed pursuant to section 6J. Warranties that survive closing. The seller warrants that the seller has disclosed to buyer and brokers all material latent defects and any information concerning the premises known to seller, excluding options of value which materially and adversely affect the consideration to be paid by the buyer. Prior to close of escrow, seller warrants that payment in full will have been made for all labor, professional services, materials, machinery, fixtures, or tools furnished within 150 days immediately preceding close of escrow in connection with the construction, alteration, or repair of any structure on or improvement to the premises. The seller warrants that the information regarding connection to a sewer system or on-site wastewater treatment facility, otherwise known as septic, conventional septic or alternative, is correct to the best of the seller's knowledge. And the last of the warranties is the buyer warranty. The buyer warrants that the buyer has disclosed to seller any information that may materially or adversely affect buyer's ability to close escrow or complete the obligations of this contract. At the earlier of possession of the premises or close of escrow, the buyer warrants to seller that buyer has conducted all desired independent inspections, investigation, and accepts the premises. The buyer warrants that the buyer is not relying on any verbal representations concerning the premises except disclosed as follows. This would be a line that if anything was disclosed to you verbally, you could add it to the contract. So the buyer warranty, this section, I just want to bring up a good point, because if the buyer loses their job, that has to be disclosed to the seller immediately, because it does affect their ability to close escrow. And it's not the buyer to the seller, it's, the seller's agents and stuff, but anything that can affect the closing of the home, you just have to disclose it immediately. I go back to the situation where I had the gift funds. The lender actually knew about the gift funds from the day we went under contract. I wasn't made aware of them until we were like mid-contract, and then they weren't getting them anymore. So it adversely affected their ability to close, but no one ever told me. And that again is another reason why the LSU is so important.
And why it's nice to work with more lenders.
Yes. Yeah, having a trusted lender that can guide you through the process is key. And the great thing about our affiliation with Starboard is that we have them right across the street. We can go ask them questions. They can come talk to our clients. Like, it's great. Our location couldn't be more perfect. Okay, so next week, we should be able to finish the contract. We're going to start on page 5, section 6, and we're going to talk about the due diligence. Again, I could probably finish it tonight, but I don't want to rush it because this is such a huge part of the contract, and there's a lot of different timelines in here, as far as like what you need to know, especially when it comes to the BINSR, because the BINSR is super important and I don't want to rush it. So I appreciate everyone coming tonight. Again, if you have any questions, please let me know. I'm always available. Have a great evening, and we will see you next Thursday.